Chair Mariani, would you like to move 739 before the committee?
Madam Chair, I would move that House File 739 be laid on the table for possible inclusion in the omnibus bill. And members, I have to admit, this is a view I haven't seen yet before, so it's pretty impressive. It's also a little bit intimidating. Madam Chair, if I may.
Yes, and then also the DE1 amendment, would you also like to move that?
Yes, Madam Chair, I would so move.
Chair Mariani, go ahead.
This is the DE1 amendment.
Oh, vote. Okay, sorry. Everyone in the audience, please bear with me. But we would like to move to have the DE1 amendment adopted. All those in favor?
Madam Chair, and this will put the bill in the shape that the author proposes to have before us.
Great. All those in favor say aye.
Aye.
Opposed, same sign. Go ahead, Chair Mariani.
Thank you, Madam Chair. Members, I'm introducing this bill in order to offer hope to those individuals who face a terrible and unjust consequence of a criminal conviction that frankly should never have been entered in the first place. Post-conviction relief exists in Minnesota precisely as a remedy for our in our criminal justice system for over 50 years to play an important role in making sure that unlawful and unconstitutional criminal convictions can be remedied even after the trial process is over. But this remedy is too often out of reach for those who need it most. Right now, if someone has a defective criminal conviction, they're limited to filing a post-conviction petition within 2 years. Exceptions exist for this 2-year period. And it is time we recognize that one of those exceptions should apply to those who suddenly find themselves in danger of deportation. Deportation as a result of a defective criminal conviction. So this afternoon, you're going to hear testimony from impacted family members and people who were faced with exile from their only country that they have ever known, our country, and the possibility that they would be forced to not only be separated from their loved ones, but having to live in a country they had never been in. Members, it does happen. I've known individuals over the years where that situation has occurred. And in keeping with our theme of community-centered public safety, such circumstances, in fact, break communities in Minnesota. So today you will hear testimony from people who can explain how the process of deportation for crimes can include deporting people who have lived here their whole lives and whose crimes can be years or even decades old. Today, we will have multiple testifiers. It's my privilege to have with us today my mayor of St. Paul, Mayor Melvin Carter. Also, Linus Chan, who is a professor and immigration attorney at the University of Minnesota Center for New Americans, and the attorney on a case you're going to hear about in a few minutes, Jenny Stray's husband's case. And then Jenny herself, who's a founder of Release Minnesota 8, and obviously an impacted family member. So members, with that, and Madam Chair, I'd ask my testifiers to come forward.
Very good. Welcome, Mayor Carter.
Thank you very much.
Could you please state your name for the record and go ahead with your testimony?
Thank you, Madam Chair, members of the committee. Good afternoon to you. My name is Melvin Carter, and I serve as mayor of the city of St. Paul. I'm honored to be here today and greatly appreciate your leadership. The fact that a public safety and criminal justice reform division even exists says much about the Minnesota House of Representatives and of each legislator around this table. Specifically, I want to thank Chief Bill Author, Representative Carlos Mariani, as well as co-authors Representative Kali Her, Representative Rod Hamilton, Representative Fu Lee, Representative Samantha Vang, and Representative Mohammed Noor. Thank you very much for your leadership. I'm honored to have the opportunity to testify before this committee and to support House File 739, a bill to ensure that our criminal justice system works for all of us. The Center for American Progress recently reported that 1 in 3 Americans have some type of criminal record due to decades of overcriminalization and mass incarceration in our country. They found that individuals with a criminal record, no matter how minor, will encounter lifelong obstacles to nearly every pillar of social and economic stability and success. This includes employment, housing, education, and immigration. For immigrants and refugees, the consequences of having a criminal record, even one that is 20 years old, and even for individuals who have rehabilitated their lives and lived as contributing community members, can quickly become a life sentence to a foreign country, a place they've never known, a place where they do not understand the language or cultural way of life. We see images on the news and hear stories of families being torn apart, communities living in fear, and local and state governments are called to respond to our communities in crisis. That's why I'm here today. I've asked Release Minnesota 8 and the many important immigration advocates and criminal justice reform supporters to bring attention and urgency to this community crisis in our city, our state, and our country. This past Christmas, as we were all celebrating, around 40 Cambodian American community members were torn away from their families and deported to Cambodia. Since 2017, ICE has conducted mass raids across the country in the Cambodian American community and deported a staggering 110 Cambodian community members in fiscal year 2018. These mass raids are not only happening in the Southeast Asian community. New Americans from Liberia, Somalia, Mexico, and other countries are experiencing the same type of targeting. These new Americans came to our country to start a new life and to escape political and religious persecution. After decades of making our country their homeland, we are now re-traumatizing entire communities. This is both unconscionable and un-American. Our nation has a proud tradition of welcoming immigrants and refugees into our communities, and Minnesota has led the way. Minnesota's first large group of immigrants came from European countries of Norway, Sweden, Ireland, and Germany. Today, Minnesota's immigrant and refugee populations are from across the globe, including Central and South America, Southeast and South Asia, East and West Africa. In St. Paul, 20% of our residents are foreign-born. 30% speak more than one language. And in our St. Paul public schools, our students speak over 100 different languages. That's an opportunity for us economically, culturally, and socially. Our city's population growth in recent years has been driven particularly by people of color, who now make up about 46% of our population. A 2018 report by the New American Economy found that immigrants and refugees play an important role in St. Paul's economy. As the drivers of population growth, they make up a significant percentage of our labor force, entrepreneurs, and state and local tax contributors. As the mayor of our capital city and global community, it is my duty to ensure that everyone in our city has access to justice, regardless of their national origin or birthplace. To ensure that all of us have the opportunity to feel safe, secure, and welcome, and to protect and support the drivers of economic growth. Last year, St. Paul partnered with Ramsey County to together invest $200,000 to start an immigrant defense fund, and we in St. Paul have also invested funding for a full-time position to support the safety and economic success of immigrants and refugees in our city. I'm here today because I can't do this work alone. The state has a critical role to play, and I'm partnering with Chair Mariani to ensure that new Americans in St. Paul and across our state have access to justice. We're living in an era of unprecedented attacks on our immigrant and refugee families, and we cannot remain silent. We are a nation of immigrants, a nation that values family and community. So let's work together to find solutions that ensure justice, access to justice for all. I would like to just call to your attention, you have in front of you a list of the coalition partners that support Release Minnesota 8. And I would also like to let you know that Ramsey County Attorney John Choi has also written a letter supporting a pathway for relief for people facing deportation as well. Thank you for your time.
Thank you, Mayor.
Thank you.
Chair, your next testifier.
Yes, Madam Chair, Mr. Linus Chan.
Please state your name for the record and go ahead with your testimony.
My name is Linus Chan. Thank you very much, committee members, as well as chair, for allowing me to speak. I'm only a recent, quote-unquote, immigrant to Minnesota, coming from far away as Illinois. So I take this as a singular pleasure in being able to address this committee on this bill and what its effects are. So to be clear, I'm here as the attorney for Ched Nin, who is Jenny's husband. I'm here as someone who's been working closely with the coalition and groups of people that have been trying to figure out what they can do about this particular issue. I am not here on behalf of the University of Minnesota. So let me give a little context about the work that I do and why it is that I believe that I was asked to testify in front of you. One, I'm an immigration attorney. I'm not only an immigration attorney, but I'm an immigration attorney for those who are facing removal. Not only am I an immigration attorney for those facing removal, but I'm an immigration attorney for those facing removal who usually have a criminal history. And not only for those who have criminal history, but those who are detained. And the question then that becomes before us is, are we deporting the right people? Are the people that are in these jails the ones that should be deported? It's obvious, right, when we talk about these issues, when we use the word criminal, and that's one of the aspects of these decriminalizing communities, what do we mean by criminal? That word has been used, of course, to describe dangerous people, people we don't want in the United States. Unfortunately, that usage of the word is becoming increasingly inaccurate. Simply because you have gone through the criminal justice system does not make you dangerous. It also doesn't necessarily make you guilty. And one of the issues this bill addresses is the question of people whose crimes that were originally entered illegally or were originally suspect at the time that they were entered, should they not have a chance to go in front of a judge and ask that judge to revisit whether or not that crime was in fact lawful, constitutional, and properly entered against them. It is important when looking at the context of this bill, one could be deceived into thinking that the language that we've included, the B6 clause, somehow gives a quote-unquote substantive right to get their crime vacated. It does not. The statute we are talking about, the time limitation statute on the post-conviction bill, only controls the question of who can bring a post-conviction petition at all. It does not address who can win a post-conviction petition. People who can win a post-conviction petition still need to show that the original conviction, whether it be 20 years ago, 10 years ago, or 3 years ago, they need to show that their conviction was legally and constitutionally suspect. If they can't, this bill doesn't do anything for them. The problem, of course, is from what I have seen, there are instances where people have had old convictions that are legally and constitutionally suspect. They could have been all sorts of reasons, from bad advice of counsel to not properly investigating whether or not there was another form of inquiry to prove someone's innocence. And of course, now, one of the things that's been very close to what's happening right here is the crime labs. What we know, for instance, the St. Paul Crime Lab is undergoing a scandal, whether or not there was bad tainted evidence. These are all things that can happen at the time of conviction, but that there is an enormous pressure for people to take a plea, to go forward, to live their lives. The 2-year limitation on the post-conviction statute is a new creature. It's important to understand that. It's only been in place for less than 15 years. It was passed in 2005. From the 1960s, from I believe 61 until 2005, there was no limitation. Other states don't have a limitation on the post-conviction relief. What this bill does is only create one exception to the 2-year limitation. And that exception is especially applicable because it addresses the people who might not have any incentive to challenge their convictions until well after 2 years. So let me just paint a quick picture for you. And it's important because these crimes do not have to be the ones that you think of. They don't have to be rape, murder. They are not the serious crimes. They could be something as simple as a possession of a controlled substance. Imagine that you are a non-citizen and you are being placed into criminal proceedings for possession of a controlled substance. You told your lawyer tells you, you know what, we could fight the case, but I also got a good deal on your case, and you can be finished with your crime, be in and out, maybe not even serve more than 90 days in any sort of criminal setting. You rely on that advice. You say, okay, good, I'll do that. And maybe this conviction happened 20 years ago. So you do that 20 years ago, you're a non-citizen, you have a green card, you've lived your life, and that's exactly what happens. You get out, you live your life. Maybe there was something worrying about the conviction itself, but you're out, you're with your family. Why would you fight that now? Why would you risk that now? Well, what I've seen, and I know exactly a situation where ICE doesn't come a-calling till 20 years later. At 20 years later is when you suddenly find out that everything you've built, your life that you've had in the United States for 40 years, has been suspect and put into danger. And why? Because of a crime that was originally suspect to begin with. But you had no incentive to appeal. You had no incentive to bring a post-conviction relief, primarily because you got to live your life until you can't. This bill would simply allow someone to make the claim that their crime that they originally were convicted of, that crime should not have been entered in the first place. It's also important, I think, to understand, second, why are we here in terms of post-conviction relief? Why is this the forum that we are asking for help on from the state legislature? And the simple answer is the federal government does not respect the state's definition of what constitutes a crime. So a quick example is, it does not matter that the Minnesota legislature has deemed petty misdemeanors to not be crimes. It doesn't matter that in the Minnesota courts, one could get a sentence suspended or what's called a stay of adjudication, which would not normally be what's considered a conviction in Minnesota state court systems. The federal system does not care. And more importantly and more relevant to this statute, the federal system does not care if you try to vacate a criminal sentence based on rehabilitation or immigration hardships. That's the rule in what's called matter of Pickering. What that basically says is, assume for a second that I am an immigrant, assume for a second that I got convicted of a crime, but there was nothing wrong with that crime. The conviction was solid, it was what should have happened at that time. I built a life for myself, but now I'm in trouble. I'm about to be deported. I go to the Minnesota courts and say, please, I don't want to be deported. I don't want to be deported. I built my life. Can you please help me? And let's assume that the judge is merciful and decides, you know what? I will grant you post-conviction relief. If that judge does so and explains it, the basis for that post-conviction is to prevent deportation, ICE will deport me anyway. Why is that important? It's important because there are limited tools that this legislature has to protect their own citizens from deportation, especially those with criminal convictions. This is the way to do it. This does not allow people to create new ways to attack their old criminal conviction. They still must be able to claim that something else was wrong with their crime. This is not going to be floodgates. I pulled out some numbers in terms of post-conviction relief, and I just want to make sure this committee understands. In 2017, which is the only date that the Minnesota Judicial Branch keeps those statistics, a total of 244 post-conviction petitions were filed. Out of that, only 63 were granted. Out of the ones in which were filed after the 2-year limitation, only 137 were filed. Only 26 in the entire state of Minnesota were granted. This is not going to lead to a whole slew of more cases. Again, even just facing deportation is not enough. I have to be facing deportation, and my original criminal conviction has to be legally suspect or unconstitutional. Otherwise, it doesn't get me through the door. So with that in mind, I just want to be clear, Jenny is going to be able a chance to tell you exactly what happened more in her case. But these are cases that I'm hearing about. These are people that are coming forward. They are afraid. They are desperate. And yes, many of them have cases in which there's at least an argument that the original criminal conviction was suspect. And the question that I think that should be asked by this committee is whether, how long and what effect should we have an unjust, unconstitutional, illegal conviction? What effect do we want those convictions to have on people and their lives? Thank you.
Thank you, Mr. Chen. Thank you for clarifying the law and what this bill would do. Chair Mariani, do you want to move to your next testifier?
Please, Madam Chair, I call on my next testifier.
Please state your name and go ahead with your testimony.
My name is Jenny Stray. I am an impacted family member and a founding member of Release Minnesota 8, an organization with a mission to provide direct support to Southeast Asian families impacted by detention and deportation through leadership development, community organizing, to bring about social and political change. I'm here to share my story and express support for House File 739. To start, I'd like to give a brief background. My father came to the U.S. in 1976 as a refugee from Cambodia. He fled war and genocide that killed nearly 2 million of the Cambodian population. He was a part of a mass refugee resettlement that stemmed from 1975 to 1985. At that time, this country recognized the damage of what a U.S.-inflicted war had done to Southeast Asian countries and welcomed almost 800,000 refugees from Vietnam, Laos, and Cambodia, of which 100,000 have chosen Minnesota to be their home. My husband, Ched Nin, was among that number. He was born in a refugee camp in Thailand, arriving in the U.S. at the age of 6. His family struggled to adjust to a new system while also still trying to grieve the loss of half their family members and 4 of his older siblings. After over 20 years of living in the U.S., he made a mistake that cost him a sentence of 2 years. Then suddenly, out of nowhere, in August of 2016, he, along with 7 other families, were put into deportation proceedings. Thus, the campaign Release Minnesota 8 was born. We tried every route to save our families. My husband's plea in criminal court was constitutionally invalid, and he qualified for post-conviction relief. However, his request was denied for being time-barred and past the 2-year time limit. We did not understand that his plea was invalid until years later. While the judge was sympathetic, he could not waive the 2-year time limit. Throughout our campaign, we were faced with many of these no's. We were being told that we were not worth the bold political moves needed to protect our families. We could not accept these answers. And with our determination and perseverance, we've been able to achieve the unthinkable and impossible, as we were able to get 3 of the Minnesota 8 released back to their families. We gained national attention for our resiliency to keep our families together, and were featured in news outlets like The New Yorker and a 30-minute segment on Al Jazeera. Today, we appreciate bill authors and Mayor Carter, who stand with us and did not say no. Release Minnesota 8 is a group of family members who have never organized or testified at a hearing, legislative hearing. But we believe it is wrong to criminalize our families and our community members with these life sentences of deportation and to be torn away from our family. We are pushed to continue to do this work for our family and to be a resource for the Southeast Asian community who are impacted by these harsh policies. We created a toolkit with national partners and the law school to discuss the organizing and legal strategies that were necessary to fight for our families. I have copies of that along with a report highlighting our stories about the impact of detention and deportation on women and girls. Our families will continue to fight for legal pathways for our families to be together, and we want to work to increase justice for all. Thank you.
Madam Chair, that concludes our testimony. I also want to point out that there should be a letter that was distributed at the beginning of the hearing from our Attorney General, State Attorney General, expressing his support for this legislation. And with that, Madam Chair, we'll stand for questions.
Thank you. Representative O'Neill.
Thank you, Madam Chair. And Chair Mariani, can you just help me understand the last sentence of the bill? I've gone over it and over it, and I'm not exactly sure how we get to the point of what actual knowledge is, and maybe you could just, on the record, just sort of put that out, so if this does go to court, they have a bar by which they can understand what that measure is.
Sure, I think I can answer that question. So the Minnesota Supreme Court in two decisions, one Sanchez versus State and Carlton versus State, read the language of the bill without that clause at all and imposed what's called a should have known standard. And they have since interpreted that should have known standard in what's called an objective way. I think the problem, of course, is a should have known objective standard. If it's not, it's very problematic because it requires the existence or looking at the possible judgment of someone that doesn't actually exist, right? So what does it mean that someone should have known that the plea was invalid? Right. What does it mean that someone should have known that something gave rise to a reason why their plea was unconstitutional or valid? So this standard actually is attempting to make it clear that what the standard that should be used is when did the person actually know that they had a claim arise, and that should be when the 2-year toll begins, right? If you know where this bill obviously does not allow people to sit on their claims, but it does require something rather than trying to be judged, having a judge later on trying to judge what a person should have known, what kind of person was, what that objective aspect of a should have known standard is. So that's the attempt.
Madam Chair?
Representative O'Neill.
Thank you, Madam Chair. That's helpful. So can you just give like an example of something that could be presented as evidence in a court of law that would show that now they know?
Sure. Well, I think one instructive example was with Mr. Nin's case itself, right? At the time, the question was, when he was first convicted and then he was first placed into removal proceedings, that is when the criminal court judge said, oh, he should have known that there was a problem. Of course, at the same time, Mr. Nin was being told by his own embassy, right? The Cambodian embassy had said, we're not going to take you back. The judge in his case said, oh, we're not going to take you back. There are other people who said, we're not going to take you back. And you've been checking in all this time. And the evidence on the should have known is when he gets the letter that says, come in now, we are going to deport you. That would be actual knowledge that he knows. Now, obviously, I admit that that is one interpretation, but I think it's instructive to see that the question isn't should he or should he not have. The question is when did he actually know that this claim can arise, right?
Representative Long.
Thank you, Madam Chair. I just wanted to thank Jenny for telling her story and coming forward. The Minnesota 8 have been incredibly brave through this process and raising up the issues of long ago criminal activity, criminal cases that had, where the families have established themselves in the U.S. for decades often, past these cases. And I just wondered if you could elaborate a little bit. How old was your husband when the incident that he got in trouble for happened, and how long ago was this?
It was in 2010, and he was in his mid-20s.
And what was your husband doing when he received the order for deportation?
Yeah. He had a criminal conviction of a second-degree assault. He had a BB gun, which he... Oh, what he was doing his job. Oh, sorry. Thank you for clarifying. So he, okay, so just, I guess, I mean, he shot a BB gun at a car, and so that's considered the second degree. So, So before that, or after, so we got married. He works as a carpenter for the Carpenters Union, Local 322. We have 6 kids. We just recently had our baby, so he's 6 months old. And he's a great father, very, very great father. He's a hard worker, and he's been a carpenter for 20 years, so.
Thank you.
Yeah.
Thanks for sharing your story today.
Yeah, thank you.
Representative Moeller.
Thank you, Madam Chair. And yes, thank you for sharing your story with us. I really appreciate it. And also, I had some concerns when I saw this because I handle appellate work and folks in my office handle post-conviction work. And so I want to thank those who've been working on this bill that did come and meet with me, and you addressed some of my concerns. But I still did have a couple of questions. And one of those really has to do with what Representative O'Neill asked about too. Mr. Chen, in the example that you gave for that has actual knowledge makes sense to me when we're talking about the B6. But I am a little worried that where it's at in subdivision C is going to apply to all post-conviction claims, and that will be very difficult to prove when someone has actual knowledge. And so I'll ask you to address that, and I'll also just say, too, in response to what you talked about, the number of post-conviction petitions brought and granted. Post-conviction typically happens after the direct appeal process. So many more people go through the direct appeal process, and then whether or not they have a direct appeal, they may decide then to go on to a post-conviction case. So that can kind of explain some of those numbers. But if you just wanted to please address to me why you think C is the right place for that, sure. And how that wouldn't be too broad in applying to many different kinds of claims.
Mr. Chen.
Sure. First of all, I confess I am not a criminal appellate defender. So I do note that there are a couple of them here, including Ms. Catherine Middlebrook. So if I screw up, I hopefully won't. But I will check in to make sure. So one of the biggest things I think is important to understand on post-conviction is that the burden is on the petitioner generally. So while I think there is the idea, well, how do we prove the actual knowledge standard, that still requires the petitioner to make that proof. And if that proof is insufficient, then that's going to be what the judge is going to decide. So I understand that there might be a concern, here as we talk, what that standard might look like. I just think it's more problematic the way it is currently interpreted by the Supreme Court. That just requires a should-have-known objective standard. I think if it was a should-have-known subjective standard, that might be somewhat better, though how do we know a judge can actually make a subjective determination on someone? But I think the combination of a should-have-known standard with a subjective standard, I think places that a little bit too far out of reach. So that's my only response to you on that. The second response, I do want to make one note. I do think it's true that there are, of course, criminal appeals that people do avail themselves. But many people plead, and when they plead, they don't get a chance to appeal. So post-conviction is the only time in which when there's a plea, that the plea might be subject to problems. Well, you're shaking your head, so I apologize. Did I misstate it? I apologize.
Representative Moeller.
Yeah, right there. I know I'm in hot water, so apparently I apologize.
Representative Moeller.
Yeah, thank you, Madam Chair. Yes, people can still appeal from a direct, from a plea.
Okay.
That does happen. I guess one other, and I know you're willing to work on language, and I guess one other issue I'll bring up, and this is really in the weeds here, but Ms. Middlebrook will understand what I'm talking about. When we're talking about the case NAFLA, and how this impacts the NAFLA decision and cases that are on direct appeal, maybe somebody did direct appeal and then presents post-conviction, what happens in those situations. So we don't necessarily have to address that now. I just hope you'll have some willingness to work perhaps on some better language, because I think that what you're trying to do here is really good, and I'm supportive of that. I just want to make sure that it's not too broad.
Sure. I don't feel qualified. I feel very unqualified to answer the NAFLA question. I've only a little bit of awareness of that case.
Representative Grossell.
Thank you, Madam Chair. And I guess maybe for the author, if you can answer this question, or if somebody else wants to jump in. I guess looking at it, you have the 2-year time frame, but the new language, I guess, is there a time limit on that portion of it, or do you have a certain amount of time that you allow them to take care of business?
Chair Mariani.
So it's 2 years on both. So the normal limit on the post-conviction is 2 years, and then subclause C, which you'll see, is another 2-year limitation on bringing the exception. So let's assume that there was a conviction that's more than 2 years old that you want to challenge on post-conviction. You're limited on bringing on that exception to 2 years, generally. I think there might be an exception under subclause 3, but I'm not completely clear, because that has a really old conviction. But the general idea is it is generally 2 years on both. So 2 years to bring a post-conviction relief petition, and then 2 years again to bring an exception to the post-relief. And this is the debate right now on the should have known or actual known standard. But when you know about that exception, you can't sit on it. You need to bring it up within those 2 years.
Thank you, Madam Chair.
Representative Grossell.
Is that something that you would want to make crystal clear in this?
I hope it is. If there is a way, we'll obviously, if it needs to be clarified, we're more than happy to help clarify that language. It's just a weird statute in the sense that it's the whole statutory is about time limits. So that's why there's like multiple time limits within time limits.
All right, members, there's 2 more people on the list. I'm going to ask you to keep your comments brief because we have another bill. Representative Pinto.
Thank you, Madam Chair. So I'm really grateful that this is being brought forward as well. I guess I'm thinking about some of the discussion we've had about the impact on children when their parents are incarcerated. Some of the work that I've been focused on early childhood, and just when the mention was of your family having 6 kids and the impact on having their dad out of their lives and out of the country, just thinking about the impact of that, and of course amplified in so many families as well. I'm grateful to have our city, Mr. Mayor, leading on this, because St. Paul has been a city of immigrants for all of its history, from all kinds of different places around the country and around the world. And so I'm really glad, of course, that's caused us to have a great vibrancy in our city. It's been wonderful. I'll admit to having some concerns as well just about the language. I think I don't practice in this area, unlike Representative Moeller, so my brain is just moving a lot more slowly. And I spoke with Professor Chan really briefly yesterday, so I think I probably want to follow up with you, and I saw Michelle Garnett-McKenzie from the Advocates for Human Rights I've worked a lot with as well. I do just have one question maybe for now on that, though. In reading the court paperwork that you'd provided, it looked to me like Mr. Nin actually was placed into immigration removal proceedings kind of right away, soon after being released, so soon after the conviction. And so as I read the bill, it seems like it would then, if I'm reading that right, then the 2 years would apply soon after, right after that. So I feel like maybe I'm misreading that, but if you can just clarify that point for me.
Sure. I think the first removal proceeding so first of all, let me be clear, there are people who do not get put immediately into removal proceedings, right? So that is, but it's a very good question, Representative Pinto. In Mr. Nin's case, the argument would be simply this. At the time he was placed in the removal proceedings, 3 different entities were telling him he didn't have to worry about removal. The judge on his case, the actual immigration judge, told him, don't worry, you're not going to be removed. His own embassy told him, you're not going to be removed. And everybody around in the immigration system says, we're not deporting anyone to Cambodia. You're not going to be removed. So in that sense, it's the claim would be the later part when he gets put back into detention and be told, you know what? Forget what everyone was saying to you in 2010. You are going to be removed. We are processing you for removal now. So that is a shift in the administrative policy. I think it is somewhat specific to these facts, specifically because he was told at the time, you're not going to get deported to Cambodia. Don't worry, no one is. And I want to emphasize this also applies to Somalia. Somalians for a long time were being told they're never going to get deported, and then they were, and then never, and then were, and then never. The seesawing back that happens on that can play havoc with people's lives. So I just wanted to address that. But that's exactly what happened in this case, is that Mr. Nguyen was told on multiple occasions at the time he was first put in proceedings, don't worry, you're not going to get deported to Cambodia.
Representative Pinto.
Thank you, Mr. Chair. Just so really quickly, so it sounds like you're saying that although that first clause in the new Section 6 applied, that he was placed in immigration removal proceedings, some of the other ones had not yet kicked in. For example, that removal was more likely than not. And so at that point, because it's an or, he could rely on the other clause, essentially. So any of those clauses kicking in.
That's exactly right. That's the intent.
All right. Thank you, Madam Chair.
Representative Considine.
Thank you, Madam Chair. Did I understand you to say that your husband's initial charge was he shot a BB gun at a car?
Yeah, he shot it. Yes, he did.
2 years? Mm-hmm. Wow, there are literally thousands of kids in greater Minnesota that are in danger of 2-year sentences then.
Is there anyone from the public that has any testimony they would like to state? Chair, do you have any closing statements on this bill?
Madam Chair, first of all, I want to thank the committee members for the rigorous and intentionally deliberate questions to understand the proposal before us. It's a bit unusual for this committee, I believe, and in the spirit of not only making sense of it, but crafting good legislation. It is my hope that that is consistently at the core of this committee, certainly at the core of this legislation. There's been a lot of efforts put into this. Thank you, Representative Moeller, for reaching out to help us continue to shape this. It is my intent to lay this over so that we can continue that process. And so when we next see it, it'll be even better. But the justice issue remains important, not only to my city of St. Paul, a city truly of immigrants, but frankly, all across our state. And so my hope is that we'll be able to act on this positively in the coming weeks. So with that, Madam Chair, I would renew my motion to or I would renew the, this is odd. I would ask that the chair lay the bill on the table for possible inclusion of the omnibus bill.
Thank you. I thank you all for your testimony. This bill will, with that, the chair will lay this bill over. Thank you.